One company controls 86% of concert ticketing in America. Its own employees called fans so stupid for paying its fees in writing. The government made a deal with that company and walked away. A jury made them pay anyway. This is why. You have bought a concert ticket. The price on the screen was never the real price. One company built the gap between those two numbers into its entire business. For years, almost nobody could prove that in court. This year, a jury finally did. Live Nation Entertainment owns Ticketmaster, its ticketing subsidiary. Together, they control roughly 86% of primary ticketing services at major concert venues in the United States. Once sports events are included, that share is estimated at 73% of the overall market. In 2025, Live Nation generated $25 billion in revenue. Between 2019 and 2024 alone, consumers spent more than $82.6 billion purchasing tickets through Ticketmaster. Ticketmaster was founded in 1976 as a ticketing company. Live Nation began as a concert promoter. In 2010, the two merged. That merger is the structural core of the entire dispute. The same company now promotes the tours, owns many of the venues, and sells the tickets. At every stage where a fan could be charged a fee, one company is on both sides of the transaction. In a 2019 deposition, Live Nation's own CEO described the company's position in one phrase. He said Live Nation had built, quote, an incredible moat around the castle of Live Nation. At trial, his lawyers argued that comment had nothing to do with exclusive contracts locking out competitors. The state's lawyers argued it was Live Nation describing its own monopoly, in its own words. This is not a new complaint? In 1994, the band Pearl Jam filed an antitrust complaint against Ticketmaster with the Department of Justice. The DOJ investigated. It declined to bring a case. The exact structure a jury would rule illegal 3 decades later existed and was flagged back then. When Ticketmaster and Live Nation were allowed to merge in 2010, the Department of Justice attached a condition, a consent decree, a legal agreement restricting specific anti-competitive behavior. In 2019, the DOJ found Live Nation had violated that decree at least 5 separate times. The violations included threatening to withhold concerts from venues that worked with rival ticketing services. Rather than taking the company to court, the department extended the agreement to 2025. The case now underway is the first time that restraint ran out. In 2022, 2 Live Nation regional ticketing directors, Ben Baker and Jeff Weinhold, exchanged messages on the company's internal Slack. They were discussing prices for parking and VIP access at an amphitheater show. Baker wrote that the prices were outrageous. He called the fans paying them so stupid. He wrote, "I almost feel bad taking advantage of them." Weinhold discussed pushing reserved parking prices $30 above the minimum, adding, "I'm done asking people for permission. I just do it now." Baker responded that he charged $50 to park in the grass and $60 for grass closer to the venue. Then he wrote the line that would resurface in federal court. "Robbing them blind, baby. That's how we do it." Those messages were unsealed and entered as evidence in Live Nation's own antitrust trial. Live Nation's CEO, Michael Rapino, was asked about them on the witness stand. He called the messages disgusting and said they did not reflect how the company operates. By the time the messages became public, Baker had already been promoted twice. He had become head of ticketing for the company's entire amphitheater division. The Slack messages were not the only allegation. Separately, the Federal Trade Commission accused Ticketmaster of tacitly allowing ticket brokers to buy tickets in bulk far beyond the limits advertised to ordinary fans. Those brokers would then resell the tickets on Ticketmaster's own secondary market at a markup. An internal email cited by the FTC showed a senior Ticketmaster executive stating the company would turn a blind eye as a matter of policy. In one example cited by the FTSC, a single broker bought 772 tickets to a 2023 Coldplay concert for about $81,000. That broker resold the same tickets on Ticketmaster's own resale platform for over $170,000. The ticket limits advertised to ordinary fans are set by the artist. According to the FTC, the company looked the other way when brokers exceeded those same limits by the thousands. Between 2019 and 2024, fees on Ticketmaster purchases totaled $16.4 billion. Some of those fees reached as high as 44% of a ticket's face value. In May 2024, the Department of Justice and a coalition of 40 state attorneys general sued Live Nation and Ticketmaster. Their goal was a full structural breakup of the company. The case went to trial on March 2, 2026. Days into the trial, the Department of Justice reached a settlement with Live Nation. The deal included a $280 million fund, a cap on some service fees at 15%, and the sale of a handful of amphitheater booking agreements. It did not require Live Nation to give up Ticketmaster. 33 states and the District of Columbia rejected that deal. They hired their own outside counsel and continued the trial without the federal government. The trial lasted 5 weeks. In closing arguments, the state's lawyer, Jeffrey Kessler, called Live Nation a, quote, monopolistic bully. Live Nation's own lawyer, David Marriott, told the jury that success is not against the antitrust laws in the United States. 6 states, Arkansas, Iowa, Mississippi, Nebraska, Oklahoma, and South Dakota, had already settled alongside the Department of Justice. 33 states and the District of Columbia had not. The jury deliberated for 4 days. On April 15, 2026, the jury reached its verdict. Live Nation and Ticketmaster were found liable on every antitrust count submitted. The verdict form ran 11 pages long. The jury answered yes to every single question the state's lawyers put to it. The jury found the companies had illegally monopolized primary ticketing and illegally tied venue access to Ticketmaster's own ticketing services. The jury also found that Ticketmaster had overcharged fans by $1.72 per ticket across 22 states over a 5-year period. Live Nation's own lawyers estimated the base damages figure at under $150 million. Under federal antitrust law, that figure is automatically tripled. Tripled, the number could approach $450 million. That is more than the $280 million the Department of Justice had already agreed to accept. Legal analysts called it the largest antitrust liability verdict ever returned against a live entertainment company in the United States. Live Nation's share price dropped roughly 6% on the day the verdict was announced. Shares in 2 competitors, Vivid Seats and StubHub, rose the same day. During the trial, the CEO of a rival promoter, AEG Presents, testified about the actual scale of the fees. He said average concert ticket fees in the United States reach roughly 25% of a ticket's face value. In Europe, where Ticketmaster does not hold the same dominant position, the same fees average around 15%. He attributed that gap directly to Ticketmaster's control of the U.S. market. The verdict does not automatically lower ticket prices. A separate remedies trial is now underway before the same judge, Arun Subramanian. The states are asking for exactly what the original 2024 lawsuit sought before the Department of Justice walked away: a full structural breakup of Live Nation and Ticketmaster. Live Nation has said it will appeal. The company argues the eventual outcome will not look very different from the deal the Department of Justice already accepted. The states argue that is exactly the outcome they refuse to settle for. The Department of Justice's own settlement still has to clear a separate legal process. A public comment period required before any federal deal can be finalized. That process is expected to run through the second half of 2026. And if the court eventually orders a full breakup, that structural change would likely be paused while Live Nation's appeal plays out. Even with a verdict in hand, the states may not see real structural change take effect this year. The federal government negotiated a $280 million deal and left the courtroom. The states that refused to negotiate ended up with a verdict potentially worth more on every count they asked for. Whether that verdict becomes a broken-up company or a modest fee cap is still being decided right now in the same courthouse. This is the Markup.